liability, or clause 17, it's still not become an act, is a right to recourse. The body and soul, as far as this legislation is concerned, deals with the rights of the victims. But 17 provides to the operator a right to recourse against others. That is, qua the victim's liability is channeled, and this channelized liability he only recovers from the operator. Is the operator entitled to recover from anyone else? Now, in this case, we were particularly concerned that if there was an American company operating a plant or a European company operating a plant, it may have been of secondary interest to us if they were the operators, whether they are able to recover from their suppliers or not. But through you, sir, the government, it's the taxpayers of India, the people of India who operate the plant. It's the government which operates it, it's the public sector which operates it. You are the trustees of the Indian people who operate it. Now, if for acts of a third party, this 1500 crores or 300 SDRs is to be paid by you, but the fault is not yours, the fault is of somebody else, should the government of India or the public sector of India be helpless in these matters? And therefore, the government, to be fair to the government, even in the original draft, did bring a provision in section 17 which dealt with this right to recourse which the operators has against others. And this right to recourse was exercisable if it was so provided in the written contract, or the second provision, which was 17B, which is the bone of contention today, if the government at that time had said there is willful negligence or willful default as far as the supplier is concerned. Now, this principle was debated, and after a lot of discussion, the standing committee came out with a formulation which was a consensus formulation. And we had hoped that when the bill is introduced in this house and approved by the cabinet, after the recommendations of the standing committee, what was the consensus before the standing committee will apparently appear in the bill itself. Now, that is where I was constrained to make this comment in the beginning, that there are some traces of the history of this bill which actually teach us how not to legislate. Even when the supplier's liability was there in a diluted form in the original bill, the standing committee strengthened it further. But when the report of the standing committee came, we found in a very clumsy manner the word and, A-N-D, and, introduced between clause 17A and B. Now, what is the impact of the word and? 17A says that there will be a right to recourse that the supplier has against the operator if there is a written contract. Now, obviously, the suppliers who today feel that they are the monopoly suppliers, there are 4 or 5 big suppliers in the world, and that for smaller parts there are many other suppliers. Those suppliers will always form a cartel and say, there is a standard form of contract, we don't provide for a right of recourse. So this law would then have become, instead of a victim's right law, it would have become a supplier's immunity law. If you only trust the written contract, there are few suppliers, a cartel would be inevitable. You already see similar arguments from that cartel coming in a large section of the media. Then if you put the word and after the written contract, and then introduce 17B, which says if there is substandard material or defective material, the operator can sue the supplier. This is preconditioned by the use of the word and. He can only do it if there is a written contract, and there will be a written contract if that monopoly supplier has agreed to put this clause in the contract. So even though there was no word and in the original bill, there was no word and before the standing committee, we saw it, and we didn't see it in the proceedings, I am told. We saw it in the final report, and in the final report we saw it, there was an original typed page 30 which did not have the word and then there was a stapled page 30 on top of it which had the word and. So this word "and" had come in subsequently, consciously and as an afterthought, to convert this bill from a victim's rights bill to a supplier's immunity bill. Now obviously this was noticed, it couldn't escape through. And the minister was very fair when he discussed with us, he agreed to delete the word "and", the cabinet deleted the word "and".
Thankful for the leader of opposition who acknowledged that the supplier's liability was very much there when the government first tabled the bill in form of Article 17B. Now, government cannot be responsible for what the standing committee does. I can only respond to the report of the standing committee when it is tabled in the House, and we look at the standing committee report. The standing committee report had the word "and", to which a leader of opposition has strong objection, and precisely because of that, we did not use the standing committee formulation, and you used the formulation which was agreed to later on.
Sir,
the standing committee report first had the act, then it was deleted, and then it was added when the report was presented to the House. That is the story. It was stapled as a new page.
Now that the
report
is before the House, it is laid, but let us not.
I can't be held.
He will not be able to say anything on that.
How the report came there, I can only be responsible.
No, whatever report is laid on the table of the House.
I cannot look at it.
Saying you are responsible. We are saying that that is the facts. That is how factually it appears.
No, that is not the issue.
So my intention, let me assure Mr. Prithviraj Chauhan, is not to embarrass the government. And when I say we insisted on the word "and" being deleted, we insisted on an adequate provision for supplier's liability. It was not a favor that we were trying to show to the UPA government. Today you are in power, tomorrow somebody else can be in power. As long as these plants are to be operated, and that's why I paraphrased it, either by the government or by the public sector, why must the government of India and public sector take the liability if the mistake is created by some third party? If the equipment is defective, if the equipment has a latent or a patent defect, I hope it doesn't. And I agree when the minister has said in the other house, and I've seen his public statements, that nuclear technology in power plants has reached a stage of almost perfection. The accidents which take place are almost negligible. In fact, only 2 have taken place in history. But after that, there has been a lot of correction, and I'm sure nothing of this kind will happen. But we have to guard against the future. And the guard against the future is that any government in future, if the supplier gives a defective equipment, it must shell out 1,500 crores from the public sector or more, 300 SDRs from the government, and have no right to recourse. Which effectively means the government of India and the Indian taxpayer pay for the wrongs done by somebody else. And that is why it compelled me that we turn our law upside down. Instead of the polluter paying, the polluter start getting paid. Or at least starts getting incentivized. Because they know that the liability will never be theirs. Now you were fair enough to say that it's the standing committee. We were still, after consultations, we deleted the word "and". But when you deleted the word "and", you came out with a second amendment. And the second intended was that you added the word "intendment" in 17B, which reduced 17B to a dead letter. That language of 17B would have been that the supplier will be liable only if the supplier manufactured that equipment with the intention of causing a nuclear incident. Now this was, with my respectful submission, sir, a very crude kind of a drafting. It was a dead letter. Such a liability, such a situation would never have arisen where anybody could say the suppliers, to be fair to the suppliers also, are not subversive element or saboteurs. That they will consciously manufacture an equipment with an intention of causing a nuclear holocaust. No supplier would do that. And if the supplier ever thought of doing that, he'll never be regarded as a supplier. Nobody will buy his equipment. They'll be out of business. Now this was introduced in order to reduce 17B to a dead letter and then virtually provide a liability-free regime as far as the suppliers are concerned. Now fortunately, as I have said, the minister was, and I say it with all sincerity, sir, He was in communication with all sections. He was flexible. He did a lot of legwork, and finally he saw reason probably in this argument that just as and was uncalled for, it would dilute supplier's liability. The word intendment being introduced in the bill itself would also dilute supplier's liability and reduce it to a dead letter. And I'm glad today in the amended form that word has also gone. But sir, one fact I wish to deal with, which really doesn't concern with this government or the minister's stand today, but where there is this large campaign going on, because you have added supplier's liability, the effect of the supplier's liability will be that you now produce a very tough law. And therefore, within this regime, nobody will be willing to make supplies to you. Suppliers, both international and domestic, are almost talking in rhythm. I was equally concerned when we heard this campaign, and therefore we wanted to test whether it's a phony campaign or does it have any real basis. So I regret to say that when India goes to the market and says, I want to buy 40 reactors or more at some stage of time, the character of the market is also going to alter. It's no longer going to be a seller's market. It will also be a buyer's market. And in a buyer's market regime, the possibility of our getting fairer terms as a condition of bargain will be much higher. And therefore, I would urge the government not to be overtaken by this campaign and negotiate those terms with a sense of confidence. Don't go into this mindset of adding the word and, adding the word intent, or go in with a defensive feeling that people won't sell to you. Because with 40 reactors to be bought in due course, it is going to become a buyer's market, and in a buyer's market, a large number of these people would come in. Sir, we have not subscribed to either of these conventions, but there is something in our law which I think sends a global trend. And this is an experience for us not only in the field of nuclear science, but in all other areas when we negotiate on international forums. So when the government of India, a decade ago or more, started taking a tough stand on an international forum like the WTO, we also gained experience, we started doing it. We were told, be a part of the international mainstream. It can't be that everything that Western Europe or America says is the mainstream, and those who don't agree are dissenters. Finally, what happened? More than 120 countries stood behind India, and they continue to stand behind India even today. And therefore, what was our stand there, which was then deviated from this so-called mainstream, became the internationally acceptable stand, putting world economic powers on a back foot as far as those negotiations were concerned. So we have a more recent example. In this very house in 2005, when after the product patent regime, we brought in amendments to the patent law, on the floor of the house, some political parties got together and then proposed amendments. The government accepted those amendments. And of patent law, insofar as it deals with pharmaceutical pricing, a unique India-specific provision was introduced. The Americans continue to criticize it even today. But then what happened? It kept our generic industry alive, and therefore this whole process of evergreening of patents has been checked as far as India is concerned. I am now given to understand that several developing countries have now accepted the Indian model, and that is now being accepted. Now translate this experience that you've had as Indian democracy and India's economy matures, that rather than come to everything that the economic powers say and say, well, that's the mainstream, we can't be dissenters. What will be the effect of the 17B that you have introduced? Sir, in the Vienna Convention, and I'm just reading one sentence from the Vienna Convention, clause 11.5 is, except as otherwise provided in this convention, no person other than the operator shall be liable for nuclear damage. So only the operator is liable, nobody else is liable. So they argue that the supplier is excluded. In the Paris Convention, the words are, except as otherwise provided in this article, no other person shall be liable for damage caused by a nuclear incident. Now, this exclusion of everybody else does exist in our law directly and by implication, that the victim can only sue the operator. But this law substantially, the core of it, the soul of it, doesn't deal with operator and supplier. Assuming 17B were not there, and I personally urge the Prime Minister to consider this. And when some representatives of the suppliers have campaigned this, this is a response which we have given to them. And we need not be apologetic about it. Assuming, sir, 17B were not there, and there was no direct or indirect reference to supplier liability, then between the operator and the supplier, the normal tort law will still continue to apply. Unlike the Paris or the Vienna Convention, it is not excluded. Under our law, there is no exclusion. So the operator can say, I have had to pay hundreds of crores because you gave me a defective equipment. He can go to court. All that 17B therefore does is to incorporate statutorily what already exists under the common law of tort. But even then, when it only incorporates the existing provision of the existing common law of tort, a hue and cry will be globally raised, oh, you brought in the supplier liability. And therefore, we won't go in for supplies. This is only, as I said, a phony argument being raised, merely to unsettle the bargaining equation between the seller and the buyer. And therefore, the government of India should never be apologetic about the clauses that this Parliament and the Standing Committee and this consensus process has sought to introduce, because that, sir, strengthens the regime as far as India is concerned. And I have not the least doubt that just as in the patent law or in the WTO, the stand that we took got internationally accepted by a large number of similarly placed economies and similar thinking people in due course of time, this deviation from the so-called international process that we have done, as we are being accused of doing, will then become the normal international norm, and the original model of the law, which was more intended to be a supplier immunity law, will also undergo some element of change, sir. Sir, I can only say in the end that there are two lessons. The good lesson from this experience has been that I can say, well, all is well that ends well. But then the second lesson which we must also remember, that when we legislate, I think it is important for the government to be always upfront and forthright about its intentions and not bring in surreptitiously when there is particularly a national mood not to accept those kinds of provisions. I am glad some of those provisions have been deleted, and therefore I reiterate, well, all is well that ends well. And with these few words, sir, I thank you very much for permitting me to speak on